You need a second? Oh. The Senate will come back to order. Privilege. While we're waiting on a couple of senators, if anybody has a point of personal privilege they'd like to talk about, the floor is open to that. I believe the senator from the 54th is trying to find his notes. I recognize the senator from the 54th on a point of personal privilege.
Normally I say good morning, but I'm going to say good evening. I'd just like to take the opportunity before we get started, while everybody's not busy, maybe write down and make a note that tomorrow we will have a legislative fellowship. It's not going to be at 7 a.m., so you don't have to get up early tomorrow, but we will have it at 11 a.m., and that is in Cap 132, and we'd love to have everybody here there to join us for legislative fellowship at 11 a.m. Thank you.
Also, while we're waiting, I noticed we have our agricultural commissioner on the floor, former Senator Tyler Harper. He was auditioning for a Yellowstone episode, and I believe he probably can pull it off. Always good to have you here, Commissioner Harper. Oh, we also have former Senator Mike Pollock here as well. Here you go, Mike. Good to have you here. Good to have you here. So, you ready? All right. I recognize the senator from the 18th, the pro tem, for a motion.
Thank you, Mr. Chairman. I move for unanimous consent to remove Senate Bill 272 from the table.
The pro tem has moved that Senate Bill 272 be removed from the table. Secretary, read the caption.
Senate Bill 272 by Senator Kennedy of the 18th and others, a bill to be entitled an act to amend Title 15 of the Official Code of Georgia annotated relating to courts is amended so as to supplement the duties of administrative judges to reestablish the Criminal Case Data Exchange Board, to repeal Code Section 15.650.3 relating to Criminal Case Data Exchange Board created membership, operation, role, and public access in its entirety. The Senate Committee on Rules recommends that this bill do pass. Respectfully submitted, Senator Barrasso, the 28th District Chairman. That completes the order, Mr. President.
If there's no objection, I recognize the pro tem to speak to the bill.
Thank you, Mr. President, and good evening, colleagues. Now we got a little energy and a little supper
Ennis, I'll present to you, I think, an easy, simple bill. This is Senate Bill 272. It really is a follow-up to some legislation that we passed last year and the House passed and the governor signed regarding the Criminal Case Data Exchange Board. The board was created, but one of the changes we need to make is to move it from the Council of Superior Court Clerks over to the Administrative Office of Courts. That really is where it needs to be. The board's currently working on uniform standards for transmitting criminal history data, such as final dispositions that apply to statewide. Our district attorneys need this current information. Our solicitors need good information. Court clerks, the court system, and judges need to know what the actual status of criminal cases are and what the history of the defendants are as they come before them, and we need to make sure the data is current. Also give some authority to district administrative judges to assist all classes within their court, within their district, and empower several councils associated with the court system to assist in the training and adoption of uniform standards for criminal records transmissions. Mr. President, if I don't have any questions, I'll be happy to yield the well.
You have no questions, Senator.
Thank you. I yield the well.
Does any senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. The question is on the passage of the bill. All those in favor will vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 20th.
Thank you, Mr. President. I ask for unanimous consent to remove Senate Bill 195 from the table.
The senator has asked that Senate Bill 195 be removed from the table. Secretary, read the caption.
Senate Bill 195 by Senator Walker of the 20th and others, a bill to be entitled, an act to amend Title 43 of the Official Code of Georgia annotated relating to professions and businesses so as to repeal Code Section 43-134 relating to licenses for transitioning members of the armed forces and Code Section 43-135 relating to expedited license by endorsement for spouses of active or transitioning members of the armed forces. The Senate Committee on Veterans, Military Affairs, and Homeland Security recommends that this bill do pass by substitute. Respectfully submitted, Senator Dugan of the 30th District Chairman. Veterans, Military, and Homeland Security offers the following substitute to Senate Bill 195, a bill to be entitled, an act to amend Title 43 of the Official Code of Georgia annotated relating to professions and businesses so as to repeal Code Section 43-134 related to licenses for transitioning members of the armed forces. Senator Walker of the 20th and others offer the following amendment to amend the substitute to Senate Bill 195 by striking lines 100, 101, and inserting in lieu thereof the following: this act shall become effective on March 1st, 2024. That completes the order, Mr. President.
If there's no objection, I recognize the distinguished senator from Perry, Georgia, to present the bill, coming from probably the most distinguished row in the Senate right there.
Thank you, Mr. President. Ladies and gentlemen, I bring to you Senate Bill 195, the Freedom to Work Act. Georgia has some pretty burdensome impediments to working, and that being all these occupational licenses that we have. Just in the Code Section 43, I believe we have 42 different occupational licenses. And according to the Institute for Justice, Georgia has the 12th most burdensome occupational licensing regimes. Senate Bill 195 attempts to address that for our military and military spouses. They are, of course, transferred all over the country and the world to defend our freedom. And when they are transferred to Georgia, if their spouse is licensed, let's say whatever license, dental hygienist or dentist or whatever, and licensed in another state, they're having to wait 90, sometimes 90, 120, 180 days to get a Georgia license, and so they're unable to work for that period of time. We don't think this is good for our military, good for our economy, and it's just not right. Most people can't afford to go that long without getting a paycheck. So what this bill does is directs the licensing boards to, if they meet the criteria defined in lines 44 through 63, if they meet those criteria and send in their application, check all those boxes, send in their fee, then the licensing board is required to send them an expedited license within 30 days. We also, I want to point out lines 28 through 31, the definition of military. Excuse me, I apologize. Lines 24 through 27, the definition of license would also include a military occupational specialty certification or other document earned in the military. And I want to speak to the amendment. I've met with the Secretary of State's office. They're supportive of this idea. They're implementing a new system with their licensing boards to hopefully become more efficient in getting these licenses out. And because they're going through this system change, and also to establish some processes to be able to implement this, they asked that we push back the effective date to March 1, 2024, which is the amendment you see hopefully on your desk. So I hope you'll support the amendment. Lastly, I just want to say this has been supported and endorsed. Several of us serve on the Georgia Defense Commission, which is a commission organized by the legislature to support and promote our military bases. And this issue comes up at every meeting we go to from the Department of Defense. It's also endorsed by the Hub Chamber Council, the CSRA Alliance for Fort Gordon, the 21st Century Partnership, and Robbins Regional Chamber. They've all put letters on your desk in support. I'd be happy to answer any questions if there are any. Otherwise, I ask for your favorable consideration, and I'll yield the well.
You do have a question, Senator. Senator from 33rd, do you wish to ask a question?
Thank you, Mr. President. Does the Senator yield?
Yes, sir.
I noticed how you ran up there to the podium. Do you know what you get when you run behind a car like that?
What is that, Senator?
Exhausted. Oh, come on now. That was funny.
And Senator, thank you. I know you as a veteran, you like this bill. Any other questions?
No, you have no further
All right,
questions,
thank
Senator.
you.
Does any other senator wish to speak for or against the measure? Chair hears none. The previous question is ordered. The question is on the adoption of the amendment authored by the senator from the 20th, who is author of the underlying bill. Is there objection to the amendment? Without objection, Amendment 1 is added. The question is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agree to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor vote yea, opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 54, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Strong, Senator, strong. Recognize the senator from the 9th for a motion.
Testing. Thank you, Mr. President. I ask for unanimous consent to lift SB 76 off the table.
Senator has moved that SB 76 be taken from the table. Secretary, read the caption.
Senate Bill 76 by Senator Merritt of the 9th and others, a bill to be entitled an act to amend Article 1 of Chapter 18 of Title 45 of the Official Code of Georgia annotated relating to the state employees' health insurance plan and post-employment health benefit fund so as to provide for state health benefit plans to cover insulin medication at a reduced rate. The Senate Committee on Insurance and Labor recommends that this bill do pass by substitute. Respectfully submitted, Senator Walker of the 20th District Chairman. Senate Committee on Insurance and Labor offers the following substitute to Senate Bill 76, a bill to be entitled an act to amend Article 1 of Chapter 18 of Title 45 of the Official Code of Georgia annotated relating to the state employees' health insurance plan and post-employment health benefit fund so as to provide for state health benefit plans to cover insulin medication at a reduced rate. That completes the order, Mr. President.
If there's no objection, recognize the senator from the 9th. Speak to the bill.
Thank you, Mr. President. Good evening, members. I bring to you today SB 76, and this is simply a bill to cap insulin costs for our state health benefit plans. Approximately 1 million Georgians are diagnosed with diabetes. I, too, myself come from a family with a long history of diabetes. My grandmother lost her legs. My great-grandmother lost her legs as a result of diabetes. My grandmother was insulin dependent as long as I knew her. She always had to take insulin shots. And my mother has diabetes as well. So I am already predisposed. Knock on wood, I don't have it right now, but I am already predisposed for this disease. And I have had many friends that have had to leave the state due to rising insulin costs. And I know some of you seen recently Eli Lilly just they are slashing their prices to 70%, which is great. But keep in mind, Eli Lilly is a corporation, and at any time, they can choose to raise that cost. They don't necessarily have to hold that cost. So we are setting a standard here, and this program is very low. 1 year would just cost the state $306,000 to cover approximately 2,400 members. The program would benefit many Georgia workers, so think about our teachers, think about all our state workers, think about that option to retain our state workers for them just to have the possibility and just enjoy the low insulin costs. So, this is widely popular right now, and, a disease doesn't have a partisan alliance. We're trying to fight a disease and keep Georgians healthy. This is important legislation. So I am asking for your favorable consideration, and if I don't have any questions, I yield the will.
You have a couple questions, Senator. Senator from the 30th. Senator from the 33rd.
Thank you, Mr. President. Does Senator yield?
Yes.
What do you call a doctor who fixes websites?
Oh my
A
God.
urologist.
Did you say
come on. That's
Did you
funny.
say urologist?
Come on, a URL-ologist. A URL.
I know. I yield the will.
Yeah, good thought. Good thought, Senator. Good thought, Senator. Senator from the 17th, for what purpose do you rise?
Ask unanimous consent to excuse the senator from the 33rd for business outside the chat capital.
Without objection. Does any other senator wish to speak for or against the measure? Senator from the 30th, for what purpose do you rise?
Thank you, Mr. President. I ask unanimous consent to excuse the senator from the 28th for business outside the chamber.
Without objection, senator from the 28th is excused. Is there objections to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor vote yea, opposed nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 52 and the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 23rd for a motion.
Thank you, Mr. President. I request that unanimous consent that Senate Bill 231 be removed from the table.
The senator has moved that Senate Bill 231 be removed from the table. Secretary, read the caption.
Senate Bill 231 by Senator Burns of the 23rd and others, a bill to be entitled an act to amend an act providing for the consolidation of Richmond County and the city of Augusta as amended so as to provide that the mayor shall be a full voting member of the commission. The Senate Committee on Slogo General recommends that this bill do pass. Respectfully submitted, Senator again of the 47th District Chairman. That completes the order, Mr. President.
There's no objection. I recognize the senator from the 23rd to speak to the bill.
Thank you, Mr. President. Colleagues, I bring you Senate Bill 231. This bill would allow the people of Richmond County, Augusta, Georgia, through a referendum to determine whether or not the mayor should have a vote in the Augusta-Richmond Commission. If approved by the voters, the bill would update the charter to allow the Augusta-Richmond Commission to be a more functioning governing body. Thank you, Mr. President. If there are no questions, I yield the well.
There are no questions, Senator.
Thank you.
Senator from the 22nd, you should be recognized. Come on.
Thank you, Mr. President. I rise in opposition to this, basically because there's just a split on the community, on the commission, about whether we should have a vote, shouldn't have a vote. It's not even an ideological split. It's not even a racial split. But it basically puts the split is now come here to us, and has actually put myself and the senator from 23rd in a bad position. So what I'm actually asking is that we vote no, so they can actually have a process to look at their charter and determine what changes they want to make. There's been ongoing conversations about giving the administrator more power, ongoing conversations about having more commissioners, less commissioners, the mayor a vote. Let them have the opportunity to have those conversations without necessarily having this over their head. And so that's basically what I'm saying to oppose this particular bill. It's not ideological, it's not racial, it's none of that. It's just process oriented, and it's really putting both of us in a box, and we just hope to move forward to where they can get their business in order. Thank you, Mr. President.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none, and the report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. The question is on the passage of the bill. All those in favor vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 32 and the nays are 22. This bill having received the requisite constitutional majority is therefore passed. Recognize the senator from the first.
Thank you, Mr. President. I ask for unanimous consent for Senate Bill 223 to be removed from the table.
Senator has asked that Senate Bill 223 be removed from the table. Secretary, read the caption.
Senate Bill 223 by Senator Watson of the first and others, a bill to be entitled an act to amend Chapter 1 of Title 31 of the Official Code of Georgia annotated, relating to general provisions regarding health so as to authorize reimbursement of patient-incurred expenses related to participation in a cancer clinical trial. The Senate Committee on Health and Human Services recommends that this bill do pass. Respectfully submitted, Senator Watson of the 1st District Chairman. That completes the order, Mr. President.
Without objection, I recognize the senator from the first.
Thank you, Mr. President. Senate Bill 223 is very simple, straightforward. It allows patients in a study for cancer trials to be reimbursed. It makes it easier for them to be reimbursed. It augments that, and that's all it does. All the Cancer Coalition folks in the state of Georgia and the major research institutions are all in favor of this. Thank you very much. I'll yield the well.
Senator has yielded the well. Does any senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bills, the yeas are 53 and the nays are 1. This bill having the requisite constitutional majority is therefore passed. I recognize my senator from the 25th for a motion.
Thank you, Mr. President. I ask for unanimous consent that Senate Bill 138 be exhumed from the table and brought forward.
Just like an undertaker right there, spoken like a true undertaker. He has asked that his bill be resurrected from the table here. Secretary, read the caption.
Senate Bill 138 by Senator Williams of the 25th and others, a bill to be entitled an act to amend code sections 15, 16, 8, and 45, 5, 6 of the official code of Georgia annotated relating to how vacancies filled, failure to appoint, and certification required, and public official investigated by special commission upon indictment, gubernatorial review if commission recommends suspension, reinstatement, and replacement or temporary officer respectively. The Senate Committee on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers of the 56th District Chairman. That completes the order, Mr. President.
If there's no objection, I recognize the senator from the 25th to speak to the bill.
Thank you, Mr. President. Ask for y'all's favorable consideration on Senate Bill 138. This just addresses how sheriff vacancies are filled here in the state of Georgia. Right now, there's 3 ways a sheriff office becomes vacant: early retirement, resignation, death, or felony conviction. This just clarifies that if the office becomes vacant, it'll be appointed by the chief judge of the circuit if there's no chief deputy. No questions, I'll yield the well.
You have no questions, Senator.
Thank you.
Does any senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor vote yea, opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 55, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 4th for a motion.
Mr. President, I ask for unanimous consent to lift Senate Bill 66 from the table.
Senator has requested that Senate Bill 66 be removed from the table. Secretary, read the caption.
Senate Bill 66 by Senator Hickman of the 4th and others, a bill to be entitled an act to amend code section 1562 of the official code of Georgia annotated, relating to the number of judges of Superior Court so as to provide for an additional judge of the Superior Courts of the Atlantic Judicial Circuit. The Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland of the 17th District Chairman. That completes the order, Mr. President.
If there's no objection, I recognize the senator from the 4th to speak to the bill.
Thank you, Mr. President. This increases the Superior Court judges in the Atlanta Judicial Circuit from 4 to 5. In the most recent meeting of the Judicial Council of Georgia, they identified the Atlanta Judicial Circuit as one of 3 circuits that needed an additional Superior Court judge. These counties are Bryan County, Evans County, Liberty County, Long County, McIntosh, and Tattnall. There has been no judge increases in 28 years, and we all know how much these counties have grown. And this is also in the governor's budget for the July 1, 23 through June 30, 24. Voted 100% in the judiciary. Mr. President, I yield a well. Please vote green.
You have no questions, Senator. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bills, the yeas are 56 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 47th for a motion.
Thank you, Mr. President. I move for unanimous consent to remove Senate Resolution 214 from the table.
The senator has made the motion to remove Senate Resolution 214. Secretary, read the caption.
Senate Resolution 214 by Senator Ginn of the 47th and others, a resolution creating the Joint Study Committee on Local Option Sales Tax and Service Delivery Strategy. The Senate Committee on Rules recommends that this resolution do pass. Respectfully submitted, Senator Brass of the 28th District Chairman. That completes the order, Mr. President.
Without objection, recognize the senator from the 47th.
Thank you, Mr. President. This resolution basically sets up a study committee that's supported by ACCG and GMA. I know everybody in the state pays taxes to a local government, whether that be a city or county or both. The purpose of this study committee is to look at some of the wedge issues that happen with sales tax negotiations and with service delivery. So I'll ask for your favorable vote on the bill or resolution as it stands. Thank you.
He yielded the well, Senator. You still want to talk about it? No, Senator, go on back. Go on. Mm-hmm. Senator has yielded the well. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the adoption of the resolution? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the adoption of the resolution. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the adoption of the resolution, the yeas are 54, the nays are 1. This resolution, having received the requisite constitutional majority, is therefore adopted. Recognize the senator from the 23rd for a motion.
Thank you, Mr. President. I ask unanimous consent to remove Senate Bill 137 from the table.
The senator has requested the Senate Bill 137 be removed from the table. Secretary, read the caption.
Senate Bill 137 by Senator Burns of the 23rd and others, a bill to be entitled an act to amend Code Section 23-411 of the Official Code of Georgia Annotated relating to definitions regarding tuition equalization grants at private colleges and universities so as to revise the definition of approved school. The Senate Committee on Higher Education recommends that this bill do pass. Respectfully submitted, Senator Hickman of the 4th District Chairman. That completes the order, Mr. President.
If there's no objection, recognize the senator from the 23rd to speak to the measure.
Thank you, Mr. President. Colleagues, I bring you Senate Bill 137. This bill expands tuition equalization grant access to Georgians for accredited private colleges and universities. We've had this program for a decade or more, actually 2 decades or more, and we're looking forward to enhancing this access so that others can take advantage of quality private education in Georgia. I appreciate the opportunity to present the bill. I would be happy to yield, and thank you for your favorable consideration.
You do have a question,
All right,
Senator.
questions. All right.
Senator from the 2nd, do you wish to ask a question?
Thank you, Mr. President. Does the senator yield?
Certainly, for my friend from Savannah.
Senator, I'm concerned about this bill as it does not have a fiscal note. And I am not on appropriations with the chairman from the 19th, but I do know he travels down I-16. And I noticed that this bill doesn't have a fiscal note, so this might have him traveling back up I-16. Any reason for that, Senator?
Well, I've had discussions with the Georgia Student Finance Commission. We have an understanding that the number of students who would be eligible to take advantage of this grant is fairly limited. It's a nominal expansion. And Senator, if you understand the tuition equalization grants, you realize that they're right now $950. They used to be $1,000. But again, a decade ago was where that number was set. So the real dollars, according to the State Department of Audits and Accounts, is roughly 147 real dollars. So we're not talking about a major expansion. We're talking about the ability to equally allow students to choose educational institutions that are quality private schools.
Does the senator further yield?
One more question, sir.
Senator, would it not be better if we had a fiscal note on a bill that impacts the state budget so that we could make an informed decision based off of the numbers?
I would agree and would concur with that. I would suggest to you that at this point in time, there are less than 600 students who would potentially be eligible for this grant. At $1,000 apiece, you can do the numbers, and the numbers are not that large, about $600,000. Now, I would also acknowledge that that would make them eligible for HOPE, as they should be eligible for HOPE because they're quality students. Thank you, Mr. President. I yield the well.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 43 and the nays are 12. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 52nd for a motion. Senator from the 52nd.
Thank you, Mr. President. I ask that the Senate remove Senate Bill 197 off the table.
Senator has moved that 197 be taken off the table. Secretary, read the caption.
Senate Bill 197 by Senator Huffstetler of the 52nd and others, a bill to be entitled an act to amend Chapter 1 of Title 43 of the Official Code of Georgia Annotated, relating to general provisions relative to professions and businesses so as to prohibit deceptive or misleading terms or false misrepresentations by healthcare practitioners in advertisements and representations. The Senate Committee on Health and Human Services recommends that this bill do pass. Respectfully submitted, Senator Watson of the 1st District Chairman. That completes the order, Mr. President.
Without objection, I call the senator from the 56th or 52nd to speak to the bill.
Thank you, Mr. President. This bill will require truth in advertising, similar to what we heard earlier today on the lawyers, that if you advertise services, that they have to be accurate on what you're qualified to do, that we have to label ourselves or address ourselves to people as who we are. I get accused of being a doctor. I'm not, and I never represent that to my patients. It went through the GORT committee. I'm sorry, this one didn't go through the GORT committee, but went through the health committee unanimously. I just heard in the last couple hours from the audiologists that they had some concerns, but I've asked them to work on those on the House side. We've had committee hearings, and I'm not hearing anything to this point, and I don't want to kill bills by a discussion, so I would just have requested them if they've got questions on this to work on the House side on it.
You do have questions, Senator. Senator from 14th.
Thank you, Mr. President. Does the senator yield?
I'll yield.
To the point you just made, is it not true that I have heard from some audiologists, but I'm really grateful to the senator for his willingness to give them a final opportunity in the House to voice their concerns about how they can use their title?
The senator knows of which he speaks.
Thanks very much, Mr. Chairman.
Okay. Senator from the 20th has a question.
Thank you, Mr. President. Will the senator yield?
I'll yield.
So I know that you are a real strong believer in the GORT committee and that process. I'm just curious why you didn't think this needed to go through the GORT committee and get the enlightenment of that group of folks.
I understand the question, and I had two bills that did go through there. This wasn't any change of any scope or anything. It was just simply saying we identify ourselves as who we are, and made the judgment call that the governor won't veto this one, as I know he's done in the past if they involve scope of practice.
Thank you, Senator.
You have no further questions.
Thank you.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Is there objection to agreeing to a report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. The question is on the passage of the bill. All those in favor of the bill will vote yea, opposed nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 54 and the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Hold on. I recognize the senator from the 45th for a motion.
Thank you, Mr. President. I ask for unanimous consent that Senate Bill 91 be lifted from the table.
The senator has requested that Senate Bill 91 be lifted from the table. Secretary, read the caption.
Senate Bill 91 by Senator Dixon of the 45th and others, a bill to be entitled an act to amend Chapter 9 of Title 34 of the Official Code of Georgia annotated relating to workers' compensation so as to extend the time period for the dissolution of the subsequent injury trust fund. The Senate Committee on Insurance and Labor recommends that this bill do pass, respectfully submitted by Senator Walker of the 20th District Chairman. That completes the order, Mr. President.
If there's no objection, I recognize the senator to speak to his bill.
Thank you, Mr. President. Senate colleagues, all Senate Bill 91 does is it extends the time before the subsequent injury trust fund is absorbed into the Department of Insurance. Currently, it's set for December 31st of this year. This bill would extend it by 2 years to December 31st of 2025. The reason for this is the department is wanting to settle as many of those cases, the outstanding cases they have left before they're absorbed into the Department of Insurance, and both departments are in favor of this bill. Mr. President, if there are no questions, I'll be happy to answer them or yield the well.
You have no questions, Senator.
Thank you, Mr. President. I yield the well.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Questions on the passage of the bill. All those in favor vote yea, opposed nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 54 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 8th for a motion.
Mr. President, I would like to ask for unanimous consent that we get the buckets and pick Senate Bill 220 off the table.
All right. Senator has asked for unanimous consent for Senate Bill 220 to be taken off the table. Secretary, read the caption.
Senate Bill 220 by Senator Goodman of the 8th and others, a bill to be entitled an act to amend Chapter 10 of Title 44 of the Official Code of Georgia annotated, relating to historic preservation so as to establish the Georgia Farmland Conservation Fund, Georgia Farmland Conservation Fund Program, and Georgia Farmland Advisory Council, to provide matching grants to certain holders or prospective holders of agricultural conservation easements. The Senate Committee on Finance recommends that this bill do pass by substitute. Respectfully submitted, Senator Huffstetler of the 52nd District Chairman. Senate Finance offers the following substitute to Senate Bill 220, a bill to be entitled an act to amend Chapter 10 of Title 44 of the Official Code of Georgia annotated, relating to historic preservation so as to establish the Georgia Farmland Conservation Fund, Georgia Farmland Conservation Fund Program, and Georgia Farmland Advisory Council to provide matching grants to certain holders or prospective holders of agricultural conservation easements. That completes the order, Mr. President.
If there's no objection, I call on the good man from Valdosta, Georgia, to speak to the bill.
Well, thank you, Mr. President. I'm glad to bring Senate Bill 220 before you. This is a policy initiative from the Office of the Commissioner of Agriculture, our former colleague who's back in the corner. But I will tell you that throughout, and hello, Tyler. Throughout, when the commissioner brought this to me, I'll tell you one thing I found out. In the state of Georgia, we have 38 million acres of land in the state of Georgia. In 1974, we had 12.6 million acres of farmland. Today, we got 9.9 million acres of farmland. In less than a generation, we've lost 20% of our farmland in the state of Georgia. This bill seeks to address that. It's the Georgia Farmland Conservation Act, creates a PACE program, which is a Purchase of Agricultural Conservation Easement Program. This bill creates the program, it creates the trust fund for the program, and it also creates the council that will annually select the properties that participate in the program. There are over 29 states right now that already have similar programs. In the state of Florida, they've been able to protect 58,000 acres of farmland. In the state of North Carolina, 28,000 acres. And it's where a farmer is going to sell basically this easement, puts his land in agricultural protection in perpetuity. There's about $450 million a year that comes down from the federal government every year that we're not able to participate in because there's a dollar-for-dollar match, whether it be state, local, or private funds, that there's a dollar-to-dollar match that comes down from the federal government to help the program. And I think this is a bill that's, if we all like to eat, we all know we got to have farmland to grow crops. And I think this is a good policy initiative. It was co-sponsored by about 38 members of this chamber, very bipartisan, a lot of support. And I will be happy to yield for questions, or I'll be happy to yield the well, Mr. President.
You do have a couple questions, Senator. Senator from the 46th, you wish to ask a question?
Thank you, Mr. President. Will the senator yield?
Yes, sir.
I'm not quite catching on what we're doing here. Are we paying farmers not to farm their property, or are we paying them to promise us they will continue farming their property?
Continue farming the property in perpetuity, yes, sir.
Will you further yield?
Yes, sir.
So what if they quit 1 year? What if they're supposed to keep farming it and they, decide not to? Do we keep paying their easement, or is it an annual thing or permanent?
No, sir. This is a one-time payment, and the land has to be used for agricultural use in perpetuity. Now, a farmer does not have to elect to do this. They can, and it's something that whenever a farmer looks at doing something like this, they would want to look at it if there's land that they don't want to put in it, or they think maybe their children may want to build a house on it one day. They would not want to put that land in this program because this program is intended to protect farmland in perpetuity.
Thank you.
Mm-hmm.
Recognize Senator from the 14th.
Thank you, Mr. President. Senator Yield?
Sure.
Senator, did you wait for Senate Bill 219 to get filed just so you could get that 20 number to match a 20%, or was it just a sign from above that we need the bill?
That was a sign from above, Senator. I think that says it all right there.
Thank you, Senator.
Thank you, Senator.
Senator, recognize Senator from the 2nd.
Does the senator yield?
Yes, sir.
Senator, is it not true that this bill, if they had it in Montana, would have helped Mr. John Dutton protect the Yellowstone?
That is 100% the truth, and a lot of people would have not have died.
You have no further questions. You have no further questions, Senator.
Thank you, Mr. President. I appreciate your favorable consideration.
Does any senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. Secretary will unlock the machine. Senator from the 33rd, for what purpose do you rise?
Yes, sir. Is it true that the senator doesn't realize that a cow that can't give milk is called a milk dud?
Senator, I missed that last part. I'm just going to take it you know what you're talking about. Senator from the 52nd, for what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that the sponsor of the bill, which he claimed was a typo, had 2 picks for the lieutenant governor in the bill and only 1 for the speaker of the House?
He's a smart man, Senator. He might be country as cornbread, but he's my country. So. On the passage of the bill, the yeas are 54 and the nays are 2. This bill, having received requisite constitutional majority, is therefore passed by substitute. I recognize senators from the 21st for a motion.
Mr. President, I ask unanimous consent to take Senate Bill 31 off the table.
The senator has moved that Senate Bill 31 be taken off the table. Read the caption. Secretary, read.
Senate Bill 31 by Senator Beecher of the 21st and others, a bill to be entitled an act to amend Article 1 of Chapter 18 of Title 15 of the Official Code of Georgia annotated, relating to general provisions relative to prosecuting attorneys so as to provide for the reimbursement of expenses incurred by the Attorney General in prosecuting a criminal case or cases due to the failure of a district attorney to prosecute such criminal case or cases. The Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland of the 17th District Chairman. Senate Judiciary offers the following substitute to Senate Bill 31, a bill to be entitled an act to amend Article 1 of Chapter 18 of Title 15 of the Official Code of Georgia annotated relating to general provisions relative to prosecuting attorneys so as to provide for the reimbursement of expenses incurred by the Attorney General in prosecuting a criminal case or cases due to the failure of a district attorney to prosecute such criminal case or cases. That completes the order, Mr. President.
If there's no objection, I recognize the senator from the 21st.
Thank you, Mr. President. Fellow senators, I bring before you Senate Bill 31. Our Attorney General is having to step in and prosecute cases that certain DAs refuse to prosecute. The purpose of this bill is very simple. If the Attorney General must go and enforce the law in a county where the DA won't enforce the laws that we passed the laws, then that DA's office needs to reimburse the Attorney General for actual cost and expenses. The Attorney General should not have to incur expenses out of his budget for doing the job of a DA that does not want to enforce our laws. Now let me tell you what the Attorney General must do. They must get a guilty plea or a guilty verdict, and he must submit his expenses to the Superior Court of that county within 15 days for reimbursement, and then the Superior Court judge will approve or not approve. Senators, I ask for your support of Senate Bill 31, and let's send a message that we want our DAs to enforce the laws that we as lawmakers pass. Mr. President, if there are no questions, I yield the well.
You have no questions, Senator.
Thank you. I'd ask for your favorable consideration.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 35 and the nays are 20. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 48th for a motion.
Thank you, Mr. President. I would ask your consideration to swoosh laboriously Senate Bill 160. To take it off the table.
All right, Senator has moved that SB 160 be taken off the table. Secretary, read the caption.
Senate Bill 160 by Senator Still of the 48th and others, a bill to be entitled an act to amend Title 34 of the Official Code of Georgia, annotated relating to labor and industrial relations so as to change certain provisions relating to employment security, to extend certain provisions relating to the rate of employer contributions and variations from the standard rate. The Senate Committee on Insurance and Labor recommends that this bill do pass. Respectfully submitted, Senator Walker of the 20th District Chairman. Senator Still of the 48th offers the following amendment. Amendment 1 to amend Senate Bill 160 by replacing 2033 with 2026 on lines 52 and 68, by replacing shall with may on line 82, by replacing 2034 with 2027 on line 103. That completes the order, Mr. President.
There's no objection. I recognize the senator from the 48th to speak to the bill.
Thank you, Mr. President. Colleagues, this is a very exciting bill that is an administrative funding bill for the Department of Labor. As you well know, our former colleague from the Senate, the great Labor Commissioner Bruce Thompson, dear friend of mine, inherited a very difficult situation. He and his team have been doing an impossible job trying to figure out what they have. And one of the things that they realized that they have was an absence of a renewal on a very, very small administrative fee that I've discussed with many of you, and it is simply a work comp claim percentage. It is a fraction of a percent that for the past 2.5 decades, employers would pay a variable rate, but an average of 2.7%, with 0.06 of the 0.27% being used as administrative fee. It lapsed. And so when it lapsed, what ended up happening was that they lost that little bit of funding. And so the two amendments that were offered simply clarify the dates of what is being assessed, and then it changes a shall to a may. It's a very clean bill. It's been vetted heavily. And with that, Mr. President, I yield for any questions.
You do have a question, Senator. Senator from the 19th. You wish to ask a question?
Thank you, Mr. President. Senator Yield.
I do, sir.
Senator, you mentioned it's a very small assessment, but it is a new assessment, correct?
So the assessment, it was 2.7. That sunset on December 31st of this year, and then it reverted back to the 2.64. So this is just bringing it back starting in 2024, bringing it back to 2.7%. So it's paid by the employer that's dealing with the work comp claim. It's not coming out of the state budget.
Will the senator further yield?
Yes, sir.
So if we pass this, though, even though it is incrementally small, I'll agree with you on that, there will be a 0.06% higher fee than we have now, correct?
Paid for by employers on work comp claims.
Recognize the senator from the 9th for a question.
Senator, do you yield?
I do.
Is it true that there are provisions in this bill that would suppress the unemployment trust fund contributions until 2026?
I don't understand the question. Suppress?
Yes.
I don't believe that that word exists in any part of this bill, ma'am.
Okay. Okay. Thank you.
Recognize the senator from the 2nd for a question.
Does the senator yield?
I do.
Senator, I'm trying to find it. Does the administrative fund already exists in law?
It did, and it expired. It wasn't renewed by the previous administration, so this is just a renewal of what was already in place. It had a sunset, and so this is bringing it back to have it in place through the end of 2026, and then it would be renewed again by this body at that time.
Does the senator further yield?
I do.
What's the accountability for such a fund? I mean, is there oversight on this fund? Who would oversee? What's the mechanisms on the checks and balances with this fund?
Well, the Department of Labor is entrusted with managing work comp for our state for all claims, and so this is just a very relatively nominal fee that would be used to fund that. So there's no oversight per se. I mean, this body oversees and our commissioner oversees the Department of Labor, so this is just a general funding bill.
Does the senator yield for one more question?
I do.
Senator, are you aware of any of the misappropriations that have happened at the Labor Department? Since I served at a time in the House, we had a lot of mismanagement of funding over there, so I'm very reluctant to vote on something that's going to have less accountability in the current times that we live in.
So I believe the primary funding that you're discussing is the move of a lot of the federal dollars that were transferred to the Technical College System of Georgia, and they now oversee a lot of those workforce development programs that previously were under DOL. So as an agency, they are a fraction of the size they once were, and I would venture to say that there is probably a larger microscope over that agency than any other at the time.
Recognize the senator from the 36 for a question.
Thank you, Mr. President. Does the senator yield?
I do.
Thank you. Currently, I don't know how much you know about this, but the unemployment trust fund, Georgia's unemployment trust fund, right now is insolvent. Isn't that the case?
Well, it was transferred away from DOL to the TCSG.
The trust fund?
Oh, the trust fund? Oh, okay. The which? Oh, it's not insolvent.
Who's hollering that it's not insolvent? I'm having trouble.
One of your colleagues is calling it insolvent.
Or do you have knowledge of that?
I do not have knowledge of that. That's outside the scope of this bill.
Well, it's not in the sense that if you suppress the employer contribution, those contributions go into the trust fund to build up for the hard times, for the lean times, and we've drawn the money out of that through the pandemic years, and it is now insolvent, is my understanding. We've had to look for federal assistance. So that's not something that you're aware of?
Not as it pertains to this bill, no.
Well, the way it pertains to this bill is that trust fund, the money that's in it comes from how the employers are assessed. And the impact of this bill is to suppress the employer contributions.
You keep using the word suppress in a way
suppress meaning
that
hold it down.
I
Boom,
understand the
boom.
definition. I'm just wondering if you know the definition of it as it pertains to this bill, ma'am.
Well, yes, the bill is addressing the employer contribution and reduces the percentage that employers would pay from 2.7 to 2.64.
That's not suppressing it. What it's doing is it's going from it was 2.7 just 3 months ago, and that sunset down to 2.64. This is bringing it back up to the level that it was. And if the previous Department of Labor had approached this body about renewing that, it just would have remained the same. So I would hardly call it a suppression.
It's keeping it down lower than it has been. Wait a minute. Let me correct myself. The percentage that they pay would be taken from 2.74 down to 2. It's down at 2.64 now, and you would restore it to up
Just
to the higher
restoring
level.
it back to the level that
That's
it
right.
has been for the past several years, yes.
And,
That's
and we
restorative,
always,
not suppressive.
Well, we always have the choice, isn't it true, of there are decisions that are made about how much to assess employers. And it's based on experience, but we, of course, suspended that to some extent during the pandemic and did not hold their layoff experience against them, did not negatively impact employers because of the conditions of the pandemic. But we have a very challenged system, and we'd love to see the employers paying into the system so that we could restore the funds that are there to release unemployment insurance payments. And
This
you
has
don't-
nothing to do with unemployment insurance payments, first and foremost. And I believe you're getting off track. And if you would look at the bill, and if you would look at sections 27 through 36, you'll see that the rate remained the same throughout COVID, and it wasn't it was unchanged. So I think you're talking about two different things, respectively.
I wasn't talking. I was talking about that employers were not held liable during that pandemic. With the layoffs were imposed by the nature of the pandemic. So typically, employers' rates are tied to their performance. That is to say, how much their employees that they've laid off are drawing from the fund. That's the performance of the
Right.
employer. That's what I was saying.
I understand.
Thank you.
Senator, you have other questions? The chair recognizes senators from the 13th.
Thank you, Mr. President. Senator Yield.
I do.
Correct me if I'm wrong, but is it not true this fee has been around for about 35 years?
Yes, sir, it has.
Thank you, Senator.
Chair recognizes a senator from the 29th.
Thank you, Mr. Chair. Thank you, Mr. President. Does Senator yield?
I do, sir.
Senator, is it not true that the last administration at DOL failed to follow through and take care of this funding?
Yes, sir, that is accurate.
Is it not all, does the senator continue to yield?
Yes, sir.
Is it not also true that what you're attempting to do with this legislation is restore that funding to the levels that the last department failed to do in order to keep things equal?
Yes, sir. This bill is exclusively restorative and not punishing or increasing in any way.
Will the senator yield for a last question?
Yes, sir.
Would you consider this a correction?
Yes, sir. That's all this is.
Thank you, Senator.
Chair recognizes the senator from the 52nd.
Thank you,
For
Mr.
question.
President. Will the senator yield?
Yes, sir.
Isn't it true that there was a bill last year that would have extended the sunset, that we knew the sunset was ending and it didn't come over and get over in time to do it, and that your bill wouldn't even be necessary if we'd done our job last year and extended the sunset? It does exactly what was going to happen last year, just continue exactly where we were for a
Yes,
number of
sir.
years.
That is exactly correct. Yes, sir.
Chair recognizes the senator from the 26th. Senator from the 26th.
Thank you, Mr. President. Gentleman, will you?
Yes, sir.
Isn't it true that it was supposed to go to 2.7? It moved back to 2.64. The experience rate comes on those employees who've been in business 10 years. That's where the rate comes from. Isn't it true that with taking it back to 2.64 rather than 2.7, you're going to extend it 2.7 to years forthcoming, but there's enough money in the trust fund that if any new employer went under, there'd be enough money to pay all the employees?
Well, sir, I respectfully would say that to be consistent, it needs to be at 2.7 for all employers on all claims. That, Mr. President, I yield the well.
Senator, you have one other question.
Okay.
If you want to take it, or you can yield.
I'll take it. I'll take it.
Chair recognizes the senator from the 53rd. And it doesn't look like he's here. All right. You have no other questions, Senator. Does any other senator wish to speak for or against the measure? The chair hears none. Is there objection to the previous question being ordered? The chair hears none, and the previous question is ordered. The question is now on the adoption of amendment number 1 by the senator from the 48th. Is there objection to the adoption of amendment number 1? Hearing none, amendment number 1 is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. The question is on the passage of the bill as amended. All those in favor of the bill will vote yea. Those that are opposed will vote nay. And Mr. Secretary will please unlock the machine. What purpose do you rise?
Parliamentary inquiry, Mr. President.
State your inquiry, Senator.
Isn't it true that the new labor commissioner was trained here in the Senate, and we ought to vote green in order to give him an opportunity to clean up this department and help out the people of Georgia?
The senator knows of which he speaks.
Yes, we do need to give a good shout out to our former colleague and labor commissioner there, Bruce Thompson there. Give Bruce a good round of applause. On the passage of the bill, the yeas are 34, the nays are 21. This bill, having received the requisite constitutional majority, is therefore passed as amended. Good to see you, Commissioner. Moving on, Senate Bill 45. Senator from the 31st, you have a motion?
Mr. President, I ask for unanimous consent to take Senate Bill 45 off the table.
Senator has moved to take Senate Bill 45 off the table. Secretary, read the caption.
Senate Bill 45 by Senator Anna Vitarte of the 31st, a bill to be entitled an act to amend Part 3 of Article 16 of Chapter 2 of Title 20 of the Official Code of Georgia Annotated, relating to health of students in elementary and secondary education so as to provide for the care of students being treated for epilepsy or seizure disorder. The Senate Committee on Children and Families recommends that this bill do pass by substitute. Respectfully submitted, Senator Kirkpatrick of the 32nd District Chairman. Senate Children and Families offers the following substitute to Senate Bill 45, a bill to be entitled an act to amend Part 3 of Article 16 of Chapter 2 of Title 20 of the Official Code of Georgia Annotated, relating to health of students in elementary and secondary education so as to provide for the care of students being treated for epilepsy or a seizure disorder. Senator Anna Vitarte of the 31st offers the following Amendment 1 to amend the Senate Committee on Children and Family substitute to Senate Bill 45 by replacing line 9 with the following from civil liability. That completes the order, Mr. President.
If there's no objection, I recognize the senator from the 31st to speak to the bill.
Did she read the right amendment? AJ's law? AJ's law? I don't think that's the right amendment.
Thank you, Mr. President. Senate Bill 45 is a great piece of legislation. And I want to recognize before I get started a young individual who worked with us on this for the last 18 months, and I know he's been waiting and sitting in the gallery all day, AJ Taylor. I want to say thank you, AJ, for working on this bill and representing hundreds, if not thousands, of families across Georgia as we've worked on this. Senate Bill 45 provides for the care of students being epilepsy or seizure disorder, provides for the completion, submission, review of implementation of a seizure action plan, requires the Georgia Department of Education to develop training guidelines and model seizure action plans for use by local school systems. It provides for the training of designated school personnel. we've done a lot of work in this bill to, I think, satisfy those parents who are impacted, the students impacted, each of our schools, to make sure that we have enough trained teachers in each of our grade levels to suffice the training. The training is not mandated in any such way. Also, we've removed all the liability to any teachers or schools related to this legislation. And with that, Mr. President, I will yield the well for questions and ask the body to support amendment number 1, naming this piece of legislation after A.J. Taylor.
You have no questions, Senator.
Thank you, Mr. President.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. The question is on the adoption of Amendment 1 by the senator, the author of the bill, senator from the 31st. Is there objection to the amendment? Hearing none, the amendment is adopted. The question is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 56 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Congratulations, AJ. I know you waited a long time for this, so congratulations. Give him a round of applause. Recognize the majority leader for a motion.
Thank you, Mr. President. And I ask for unanimous consent to move SB 203 off the table.
The majority leader has made a motion, and let's read the caption.
Senate Bill 203 by Senator Anna Vitarte of the 31st and others, a bill to be entitled an act to amend Article 3 of Chapter 4 of Title 20 of the Official Code of Georgia Annotated, relating to industry services training programs so as to provide for tuition-free programs that relate to the operation of a commercial motor vehicle for veterans. The Senate Committee on Transportation recommends that this bill do pass. Respectfully submitted, Senator Dolezal, the 27th District Chairman. Senator Anna Vitarte of the 31st offers the following amendment. Amendment 1 to amend Senate Bill 203 by replacing lines 7 and 8 with the following: operating solely intrastate, to provide a short title, to provide for related matters, to repeal conflicting laws, and by deleting lines 47 through 54. That completes the order, Mr. President.
Majority Leader move, but there is objection. Objection from the 13th. Would you like to speak to the motion? All those in favor of it coming off the table will vote yea. All those opposed, nay. Secretary will unlock the machine. Senator from the 27th, what purpose do you rise?
Mr. President, is it not true that this motion was made by the majority leader of the Republican Senate caucus? Therefore, it is a caucus position.
The senator knows what he speaks. So. On the motion has passed. The yeas are 28, nays are 27, and the motion has prevailed. Motion passed, excuse me. I recognize the senator from the 31st to speak to the bill.
Thank you, Mr. President. Senate Bill 203 touches on several issues, and I'm going to go through all of them. Today, we have a supply chain crisis in this country, and everywhere you look, grocery store shelves are either empty, the choice is limited, or the inventory is low. While much of the chain crisis is a result of lack of leadership at the United States Department of Transportation at the White House, there are things we can do here in Georgia to lessen the pain of businesses and consumers. The most important thing we can do to fix our supply chain is to create jobs, incentives to encourage more truck drivers in this state and across America. The American Trucking Association estimates that America needs almost 80,000. Now, let me say that again, 80,000 more truck drivers, a number that could balloon to 160,000 in 2030. The Trucking Association also estimates that over the next 10 years, the industry will recruit nearly 1.2 million new drivers into an industry to replace retiring drivers, drivers that otherwise leave the industry, and additional drivers needed as a result of growth. Addressing the shortage of truck drivers is exactly what this bill I present today does. First, the Trucking Opportunity Act of 2023 repeals Georgia's direct action statutes, which allow personal injury attorneys to sue individuals at the same time they're suing motor carriers and our truck drivers across the state. Direct action lawsuits lead to higher settlements, frivolous claims, which could put motor carriers out of business, driving up the cost of goods that they're putting on your tables and my tables, creating a lawsuit tax that's ultimately paid by the people we represent in our Senate districts. Just a handful of states have direct action statutes, and the last thing that this economy needs is attorneys getting rich off the backs of blue-collar truckers forced to pay higher premiums and settlements while making goods we make more expensive. Second, this legislation codifies the hours of service variance that is allowed under federal regulation. This hours of service variance is granted by the Department of Public Safety in 2014 via an administrative order. The variance has subsequently been extended on a temporary basis many times. The Department of Public Safety has monitored whether the variance has caused any potential safety or enforcement issues in the field and has found no significant incidents. This variance directly affects the income of trucking industry employees who can earn an hourly wage. Making the truck industry more attractive to drivers requires us to evaluate regulations artificially limit how much a worker can work. Additionally, this variance is essential to the timely delivery of materials and construction materials that are vital to the critical infrastructure in every member's district across the state. As Congress spends billions of dollars on infrastructure improvements, we need reliable supply chains to ensure the timely completion of projects. Finally, this legislation provides free tuition for veterans through the Georgia Technical College system wishing to enter the trucking industry. Mr. President, my father was a Vietnam veteran and became a mechanic in Vietnam and after leaving the service. I am a proud product of a blue-collar, middle-class family that was supported by the trucking industry. I can testify firsthand that this industry offers hardworking Georgians a career to be proud of, and I can think of no better way to thank someone for their service to the United States than offering them a good, high-paying job in Georgia. Mr. President, at the end of the day, this bill is very simple. You're either with blue-collar truckers and working Georgians and working Americans across the state, whether you're in Atlanta or you're in a rural community or you're working on a farm or you're trying to fix a truck like my dad did for over 30 years between the military and the private sector. These families have to every single day build a budget, live to the budget, and put food on the table for their kids, their grandkids, and for the next generation like my dad did. Or you're on the other side, living off a commission of what's going on in the courtroom every single day and not with blue-collar truckers and veterans in the state that want to make Georgia the #1 place to do business for the next decade. So if you're with me, Mr. President, you vote with the veterans and the blue-collar truckers. If you're not, you can vote with the attorneys in the courtroom trying to make commissions. Mr. President, I ask that the body vote against any amendments on this bill except for mine, which strikes the last section of the bill, because those amendments are not friendly, again, to blue-collar truckers and Georgians trying to work hard. With that, Mr. President, I yield the will. Thank you.
The senator has yielded the well. We've got a couple amendments here. Secretary, read the captions.
Senator Strickland of the 17th offers the following amendment, Amendment 2, to amend Senate Bill 203 by striking lines 24 through 53. Senator Tillery of the 19th offers the following amendment, Amendment 3, to amend Senate Bill 203 by amending line 55 so that it reads as follows. This law shall become effective for any insurance carrier within 60 days after the commercial indemnity insurance of such insurance carrier is reduced by 25% of the average rate charged in 2022. Provided, however, joinder shall be permissible for any insurance carrier charging an indemnity insurance rate equal to or above the average rate charged in 2022, all laws and parts of laws in conflict are repealed. That completes the order, Mr. President.
I recognize the senator from the 19th to speak to the amendments.
Thank you, Mr. President. Do you wish for me to address the underlying bill now too, or just the amendment?
So, yeah, you can speak to the underlying bills too, Senator.
Senators, thank you for letting me talk to you about Senate Bill 203. We joke about lawyer bills, and let me tell you, I am the first to tell you when someone made a really good move. And the move to make this position be a caucus position and bring the motion by the majority leader is an absolutely amazing procedural move to get us to the place we are right here today. If that move had not been made, we probably wouldn't even be debating this bill. The reason being is when we debate these lawyer bills, most folks in the audience who aren't lawyers, their eyes glass over. They don't want to get involved in a debate that they know a little bit about, but maybe not a whole lot about. And they don't really want to be stuck in a position where they think about, if this bill was me one day, this person who was hurt was me, or this company that was sued was me, would I respond differently? We want to think that we're intellectually honest, when the truth is, oftentimes we probably aren't. Senate Bill 203 has some real problems, and I appreciate the senator from the 31st, represents the area where my family grew up. But I think some of the items that are addressed here in his bill are addressed in a way that leave Georgians in a place that they're actually less secure. For instance, I know his Amendment 1 strikes lines 47 through 54, Section 6, but it doesn't do anything to address the other portions of his bill, like Section 3 and Section 4 and Section 5. it's couched in the terms of being something that's pro-veteran. Well, how could we be against that? You're going to see an amendment from the senator from the 17th later on, Amendment 2, that would allow you to vote for it and still be pro-veteran and remove the things that probably would be objectionable if it were your family or your constituent that was involved in an accident that would involve something like this. What does Section 3 do? We had a debate about something called direct actions earlier in this year in different rooms of this building. And in that debate, we realized that if you take the direct action statute in Georgia, which is only recognized in about 6 to 10 states, and pull it out, you actually create other issues with Georgia law. Well, what would those be? Well, in Georgia, when you have a commercial insurance policy, it's generally not a general liability policy. What's a general liability policy? That's what you have on your car. So when you have a wreck in your car and you're represented by Progressive or Allstate or State Farm or one of those entities, they have a duty to defend you. They have a duty to show up. They have a duty to pay costs that you are assessed because of a court case or because of a settlement. When you're dealing with commercial cases, though, they aren't quite the same. See, those are indemnity policies. Well, what does an indemnity policy mean? An indemnity policy means that you had to incur the cost to begin with, and once you've incurred that cost, someone then will come back and pay you back for it afterwards. The duties to defend are not the same. There's often additional things in the policy that say someone who is insured by one of these policies has to do. And if they don't do those things, then there very likely may be little to no insurance monies available at all. There is an instance just across the state line in our state right now about a situation concerning this case. It was a truck driving on I-75, had just crossed the Tennessee line. Tennessee doesn't have a direct action statute. So what happened when that truck, which with our weights right now would be 80,000 pounds, could be 88,000 pounds by the end of this month, hit a regular passenger car. The truck was driven by someone who was not from Georgia. There are questions about their legal status in this state, in this country. And when that person then leaves and is not able to be served, and you're the person who was injured, what do you do? Well, in Georgia, you can file a direct action against the insurance company and bring your claim anyway. What normally happens in that instance is the insurance company realizing, hey, look, we're kind of on the line for this. They track down the person who hit you. They track them down. They bring them up to answer discovery. The case goes forward. If it settles, it settles. If it's tried, it's tried. But you're not left standing in a courtroom with a defendant that you can never get service on. Can Georgia do without a direct action statute? Yes, we probably can. But if we're going to do that, we also need to have anti-subrogation and anti-indemnification clauses that require the commercial insurance carrier to act just like a general liability policy carrier. That part of the senator from the 31st bill is not stricken in this action. I bring you then to Section 40. It raises the hours for an intrastate carrier. And that's a policy decision for this body to make. But look at what it raises it to. It says that a truck driver can drive for 12 hours, provided they're not on duty more than 16 hours. Does that make our roads safer? It says that they can drive 70 hours in 7 consecutive days, or 80 hours in 8 consecutive days. Why would you need to divide those out? Something more is afoot here. Something that doesn't make us safer should we pass it. Last but not least, I know the senator from the 31st made some great statements about being with the truckers or being with the lawyers or being with the folks who are earning commissions. Well, I want to tell you, truckers are paid on commissions too, Senator. But there's one big point I think we do need to make, is if this is about what the bill's sponsor, or the bill's sponsors in the halls at least have said it's about, which is making Georgia safer for insurance, making it a better place and lowering premiums for Georgians, then let's be honest about it. And that's why I've offered to you amendment number 3. Amendment number 3 is very, very clear. It calls the hand on the table. It says, hey, this bill can do away with direct actions. It can say you can drive 80 hours in an 8-day week. It can say all these things. It can even help the veterans. But it only becomes effective when insurance rates by that carrier fall 25% based on the average rate that they charged in 2022. If you want to vote for the bill and you want to call someone's hand on the carpet, Amendment 3 is your way to do that. Amendment 3 then says, if they do what we heard this will do, and it reduces insurance rates across our state, then the bill's effective and everything's fine. But you'll have people later tell you, you shouldn't vote for Amendment 3. Because they know it's not going to do that. They don't think it's going to drop insurance rates 25%. But if it will, you'll have, and Amendment 3 passes, you've got me as a yes on this bill. Thank you, Mr. President. If there are no questions, I'll yield the well.
Senator has yielded the well. We've got another amendment. Secretary, read the caption.
Senator Moore of the 53rd offers the following amendment, Amendment 4, to amend Senate Bill 203 by removing sections 3 and 5. That completes the order, Mr. President.
Recognize the senator from the 53rd to speak to the bill.
Thank you, Mr. President. I offer Amendment 4 today because I have grave concerns about this legislation just because of Section 3 and 5. Everything else in this piece of legislation, in my opinion, is good for business, it's good for the trucking industry, and it's good for lower cost across our state. But just like the author of this piece of legislation, my father, too, is a veteran, and he was in the trucking industry. And growing up, I got a good experience as what it means to be a part of a family of a small trucking company. But when I see direct action being removed from our current law, it gives me a lot of concern. Because going back home, when I talked to small trucking companies, they were afraid of the big strong arms on the billboard. And that's why they purchase insurance. But they are equally as afraid of big insurance companies. You see, those big insurance companies, they can hire hundreds of times more attorneys than a small trucking company can. And when a small trucking company gets sued with a big settlement and the entire wealth of that trucking company is, say, less than $1 million, what does that trucking company do? Well, it'd have to go bankrupt and hopefully maybe get reimbursed by the insurance company. I heard in committee from the insurance commissioner and from others that talked about the high insurance rates in our state. And that certainly pulls at my heartstrings. I agree. This state does have high insurance costs when it comes to commercial motor vehicles. But direct action is a protection of our small trucking companies. And I think a lot of people think that, because we're so regulated in trucking, that there aren't any outlaws out there on the highways. Well, I've been out there on the highways, and there are outlaws. There are people who don't abide by the letter of the law, the people who will get into an accident and will disappear. But, Mr. President, that's only one of the many reasons. I ask that you consider my Amendment 4, and if there's any questions, I'd yield.
You have no questions,
Okay,
Senator.
thank you, Mr. President.
Senator from the 17th, you'd like to speak to your motion and the underlying bill?
Thank you, Mr. President. So I have Amendment 2. I'll start by saying this. I get the strong play to get this bill on the floor. What I don't get is not taking questions on it. I had questions I want to ask, and so I'll ask them in the well instead. First off, we know somebody really, really wants this bill. They want it so bad that they had it in different bills. They couldn't move forward, so this one's here. They couldn't put it through the committee with the lawyers to look at it. And I get it. Again, not everybody wants to sit through those long, exciting hearings that we have. But I think the senator from the 19th outlined, as an attorney, some of the issues that people see in the law if you just adopt this bill. But the senator from the 53rd, who's not a lawyer, brought up the bigger question to me on top of that. Is so if you're not going to sue the carrier, if you're not going to have the person that agreed by contract to be the one on the hook when there's a lawsuit. The person's getting paid for that, by the way. So if they're going to be now drawn out of the law and we're not going to sue them, who are we going to sue? And that's where my big concern, we all should be concerned, no matter how you feel about lawsuits, even if you put that we're a hellhole on your mailers that you mail it every time you run for office, no matter how you feel about that, do you care about the trucking companies in our state that are going to be the ones left on the hook? Because that's who's left to sue. There's going to be lawsuits. Things happen when you're carrying all this weight down the road. This stuff's going to continue. That's not going to stop. But why do they want this bill so bad? Because they don't want to be sued. That's what they're saying. So who's going to be sued? It's going to be your trucking companies, your small businesses in your district. And then what happens when they don't have the money to pay because the insurance carriers say, oh, we weren't sued. There's no reference, as Senator from the 19th mentioned, about subrogation, identification, all legal terms. But that means, can they wiggle out of their obligation, say, oh, we're not covering this one? Now, mom and pop trucking company has to answer directly for a lawsuit, and they got to pay for a lawyer, even though they paid insurance for years and paid in to have this coverage. We're not even talking about the person that was hurt. Let's just set them aside for a minute. Let's talk about the small businesses caught in the middle of all this, too. I don't know the answer. I'm no expert on this, but the questions I would ask if this ever came up with someone that was presenting it would take questions. Why do you want this so bad is the first question I'd ask. Who's going to get sued if the carriers aren't being sued? Second question I'd ask. How does us not having identification or subrogation laws in our state impact this? Third question I would ask. How do we deal with someone we can't serve? How do we deal with a company that's going bankrupt, doesn't have any assets, doesn't exist anymore once they're being sued? You can't serve them that way. How do we deal with a company that actually does file bankruptcy? These are all questions that should be asked. No one can answer those questions tonight because they won't take questions. They can't answer them. So what do you do when they can't answer questions about the bill that you need to know before you vote on this? Well, you support the amendments. You support the senator from the 19th that says if this is about lowering costs, we'll make it effective when the costs are lower. I can't imagine voting against that. You could accept the amendment from the senator from the 53rd that goes back to just supporting the veterans, I think, is basically what that would do, leaving Section 1 of this bill there, since we've already taken out Section 6 at this point with the First Amendment. And you can support my amendment. My amendment would leave Section 1 intact, so you can still do the great things here that deal with veterans, but not get into all these things we don't have answers for tonight. And so with that, Mr. President, I'll be happy to take any questions anybody has of me.
You do have a question, Senator. Senator from 31st, you wish to ask a question?
Thank you, Mr. President. Does the senator yield?
Yes, sir.
So one question I have is this really about service of process and finding the driver, or would you be okay with dismissing the insurance company from the suit once the driver or company has been properly served from the lawsuit?
I don't know. I'm concerned about the service issue, and so I'm also concerned about whether or not a trucking company will still be covered by the carrier. So in your hypothetical, I guess, as long as I had certainties in the law that the trucking company would still be covered in full for the policy they paid for, and that we have the parties at the table, then it sounds reasonable what you're saying. That's the kind of discussion we should be having.
Okay. Does the senator further yield?
Yes.
I guess that's what I'm trying to drive at is, is it really about service and process, or are we really focused on, how much money we can really reap from the insurance company?
No, Senator, I don't think that's a fair thing to say, because this is not about how much money you can get from an insurance company. My questions I have are we addressing the other issues in the code? If you're going to strike these sections that do away with the ability of having a carrier answer for their policy directly as a party, again, maybe you can answer why you want to do that. How are we saving money? Are we not covering cases? Are we not going to cover companies? Assuming that's not the case, surely that's not the case, then how do we deal with the other holes in the law when it comes to make certain that the carriers are still going to provide a defense for our mom and pop trucking companies? And that's the question I'd like answered.
Thank you, Senator.
Thank you.
You have one more question, Senator from 14th.
Thank you, Mr. President. Senator Yield.
Yes, sir.
Senator, is it not true that in committee on one version of the direct action bill that some of the testimony we heard from one of the bill's authors was more claims equals more losses, meaning basically that the point of this bill is to reduce the number of valid claims that get to be alleged against these organizations, which means that there are people out there who are getting injured not being made whole?
Yeah, and to be fair, I wasn't in the committee, but if that's what they said, then I'm sure it's what was said in committee.
Thank you, Senator.
Thank you.
Yeah, no questions, Senator.
All right. I ask that you support Amendment 2. Otherwise, I ask you to oppose the bill. Thank you.
Senator has yielded the well. Does any other senator wish to speak for or against the measure? Chair hearing none. Is there objection for the previous question? Yeah, I'm going again. Is there objection for the previous question to be ordered? Chair has none. The previous question is ordered. I recognize the senator from the 31st to close the debate.
Thank you, Mr. President. As I close, I do want to, tell my fellow senators from the 53rd, the 17th, and the 19th, I do love you. But at the same time, I'm going to tell the body, as the commercial says, don't get strong-armed into voting for the, voting against this bill. That's what this is about. If we want to talk about extending the hours of truckers to earn more money, put food on the table, data that is presented by our own Department of Public Safety, the men and women in law enforcement that monitor this industry up and down all of our state and U.S. highways, if you don't believe them, I don't know what to tell you. To the senator of the 19th, or I believe your comment was, truckers, in terms of, they earn a commission. Yeah, they earn a commission, but they ain't making 40% and millions of dollars on these cases to put food on the table. At the end of the day, we can debate this all day long, and I know this issue is not going away. I'm not backing down from this issue, regardless of what gets thrown up on that board. But, we want to talk about liability, indemnification. Those are two separate things. We want to talk about the impacts of where we're at with our economy. I'm not going to get up here and give you a courtroom answer. I didn't go to law school. I'm not an attorney. I come from a blue-collar family, just like the almost 200,000 citizens I represent in West Georgia that need relief. They need help. And if we want to start businesses and we want to see our truckers survive at the end of the day, and we want to put veterans in school and help them, just like my dad, then this is the bill for you. At the end of the day, again, I will reiterate, I understand and appreciate the intellectual debate, but to me, this is a very simple bill. This is very simple. Again, blue-collar truckers, moving product to serve our families throughout this state, regardless of where you're at, and supporting veterans, or the contrary. With that, Mr. President, I yield the well.
The senator has yielded the well. The question is on the adoption of Amendment 1. Adoption of Amendment 1 authored by the senator from the 31st. Is there objection to Amendment 1? Without objection, Amendment 1 is adopted. Now we move to Amendment 2 from the senator from the 17th. Is there objection to Amendment 2? We have an objection from senator from the 31st. All those in favor of Amendment 2, vote yea. All those opposed, nay. Secretary, unlock the machine. Senator from the 31st, for what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that Amendment 2 does not support truckers and does not support the industry that puts food on the table in the state of Georgia?
That's for each and every senator to determine themselves. On Amendment 2, the yeas are 31, the nays are 25, and the amendment is adopted. On Amendment 3, authored by the senator from the 19th, is there objection? Senator from the 19th.
Thank you, Mr. President. In light of Amendment 2 passing, I withdraw Amendment 3.
The senator for the 19th has withdrawn Amendment 3. Is there objection to him withdrawing Amendment 3? Without objection, Amendment 3 is withdrawn. And on Amendment 4, it is because the entire section, Amendment 2 passed, there's no reason for Amendment 4, so it is put forward. Senator from the 31st, what purpose do you rise?
Mr. President, I make a motion to table Senate Bill 203.
The senator from the 31st has made a motion to table Senate Bill 203. Is there objection? There's objection. There is objection. All those in favor of the motion signify by voting the yay switch. All those opposed, voting no. Secretary, unlock the machine. Senator from the 19th, for what purpose do you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Would we not still want to vote green so we can pass the underlying Veterans Act that was the big part of this bill?
Senator is passionate about what he speaks. Senator from the 17th, what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true to support the veterans of this state and the mom and pop trucking companies, and to correct my colleague to my left here, Senator for the 19th, we should vote red at this moment?
Senator knows that every senator has a red and green button. On the motion, the yeas are 19 and the nays are 36, and the motion fails. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill as amended. All those in favor of the bill vote yea. Opposed, nay. Secretary will unlock the machine. Senator from the 41st, what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that a green vote is a green vote for veterans?
That seems to be the theme, Senator. On the passage of the bill, the yeas are 54 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed as amended. Let's take about a 10-minute recess. Take about a 10-minute recess out of that one. I think there's some folks got to figure out what just happened. Senate will come back to order. Senate will come back to order. I recognize the senator from the 56 for a motion.
Thank you, Mr. President. I move unanimous consent that Senate Bill 217 ascend from the table.
Senator has moved that Senate Bill 217 be taken off the table. Secretary, read the caption.
Senate Bill 217 by Senator Albers of the 56 and others, a bill to be entitled an act to amend Chapter 2 of Title 40 of the Official Code of Georgia Annotated, relating to registration and licensing of motor vehicles so as to provide for the offense of an operation of a motor vehicle with a fraudulent license plate. The Senate Committee on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers of the 56th District Chairman. Senator Albers of the 56th District and others offer the following amendment, Amendment 1, to amend Senate Bill 217 by replacing lines 59 through 64 with the following: B, for a second conviction, a fine of $500, and C, for a third or subsequent conviction, a fine of not less than $750 and imprisonment for not less than 15 days. That completes the order, Mr. President.
Without it, unless there's objection, I recognize the senator from the 56 to speak to the bill.
Thank you, Mr. President. This is the Eliminating Ghost Plates Act. First, I want to give credit to one of our interns this year. His name is Sean Cunningham. He's right over here on the side of the wall. I ask each one of my interns, similar to I do any students I talk to come up with great ideas. And this was Sean's idea from the beginning. He went out and met with all the interested parties, came back, worked with Legislative Counsel to actually draft this bill, and came to committee to testify on it to get it passed, and did a phenomenal job. And with this bill is to make sure ghost plates, so imagine a license plate in the back of your car that is covered so much that a police officer cannot see that plate anymore, or it's sprayed with something reflective that it comes back. This is very dangerous when we're going after or chasing bad guys, when we don't know when we can run those plates who might be in that car. That could be a murder suspect in that car. It could be that there's someone who's been kidnapped. Being able to read that license plate is critical. So this bill adds some stiffer penalties, cleans up the language, and I want to thank several of my friends and colleagues, Senator from the 14th and others. You're having an amendment dropped off today that's going to make those penalties consistent with the same amount of time we give when someone is convicted of a DUI. So great work together and good teamwork. This is a great bill that will help us pursue the gang members and bad actors that are committing crimes, while at the same time making sure we have balanced justice. If there are no questions, Mr. President, I would yield the will.
You've got one question, Senator. The senator from the 33rd.
Thank you, Mr. President. Does the senator yield?
I certainly do, to my good friend.
What does Casper and your bill have in common?
Something about a ghost, I'm sure, Senator.
I don't know. I thought I'd ask.
Thank you, and that amendment is being handed out right now, but it's pretty straightforward. For the first offense, there's no minimum. For the second, it adds it to 15 days, and then in the third, if it's combined with a felony, makes that 30 days.
You have no further questions, Senator.
Thank you, Mr. President. I ask for your favorable consideration.
Does any other senator wish to speak for or against the measure? question is on the adoption of the amendment. Is there objection to the amendment, the adoption of the amendment? Without objection, the amendment is adopted. Is there objection to agreeing to a report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill as amended. All those in favor of the bill vote yea. Opposed, nay. Secretary will unlock the machines. On the passage of the bill, the yeas are 51, the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed as amended. I recognize the senator from the 20th for a motion.
Thank you, Mr. President. I ask for unanimous consent to remove Senate Bill 240 from the table.
Senator has requested that Senate Bill 240 be taken from the table. Secretary, read the caption.
Senate Bill 240 by Senator Walker of the 20th and others, a bill to be entitled an act to amend Title 47 of the Official Code of Georgia annotated relating to retirement and pensions, so as to revise the minimum and maximum allowable benefit multiplier for current and future retirees to require certain Social Security coverage of all employees of a political subdivision who are members of the Public School Employees Retirement System. The Senate Committee on Retirement recommends that this bill do pass by substitute. Respectfully submitted, Sarah Williams of the 25th District, Chairman. The Senate Committee on Retirement offers the following substitute to Senate Bill 240, a bill to be entitled an act to amend Chapter 18 of Title 47 of the Official Code of Georgia annotated relating to Social Security coverage for employees of the state and its political subdivision so as to require certain Social Security coverage of all employees of a political subdivision who are members of the Public School Employees Retirement System. That completes the order, Mr. President.
Recognize the senator from the 20th. Without objection, I recognize the senator from the 20th to speak to the bill.
Thank you, Mr. President. Senate Bill 240 deals with the Public School Employees Retirement System. Most of us, probably all of us, are aware of the Teacher Retirement System, TRS, which is for your certified employees at your public schools, and it's a very rich defined benefit plan. Your classified employees, which are your school bus drivers, your cafeteria workers, your custodians, your maintenance workers, they are not covered under TRS. They are covered under the Public School Employees Retirement System. Chairman Robertson had a meeting, a hearing over the interim in Columbus on a Saturday morning, and we heard from participants in the PSERS program and some school folks, and I was shocked to learn what the benefit is for your public school employees retirement system. I think you'll be shocked to know too. The current benefit is $16 per year of service per month. What that means is if you have a 30-year employee of a school system that's a school bus driver, a cafeteria worker, they receive at retirement $480 a month. Not hardly enough to live on, I think you would agree. what also was brought out in this hearing is that some of these school districts do not include these folks in Social Security. So they're not covered by Social Security, and they're only have this PSERS retirement program. They may or may not have another qualified program that the school, a defined benefit program that the school system is providing. So what this bill does, it requires the ERS, Employee Retirement System, to survey all of our school districts to determine whether or not they are including these employees in Social Security, and if not, what qualified plan do they have them in, and we will get details of that. And then it also requires the school system to, after a certain point in time, include them in the retirement, Social Security. So that's what it does. I'd be happy to answer any questions.
You have no questions, Senator.
All right. I'd ask for your favorable consideration. Thank you.
Senators yielded the well. Does any senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agree to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary unlock the machine. On the passage of the bill, the yeas are 55, the nays are 0. The bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 44th for a motion.
Mr. President, I ask for unanimous consent to remove SB 4 from the table.
Senator has asked for its SB 4 to be removed from the table. Secretary, read the caption.
Senate Bill 4 by Senator Davenport of the 44th and others, a bill to be entitled an act to amend Part 3 of Article 6 of Chapter 2 of Title 20 of the Official Code of Georgia Annotated, relating to educational programs in elementary and secondary education so as to enact the Blind Persons Braille Literacy Rights and Education Act. The Senate Committee on Education and Youth recommends that this bill do pass, respectfully submitted by Senator Dixon of the 45th District Chairman. That completes the order, Mr. President.
Recognize the senator from the 4th. Speak to the bill. Senator, I got a feeling if you're brief, you'll be very successful. It's just a hunch.
Thank you very much, Mr. President. Senators, I bring forth Senate Bill 4 to the floor, the Blind Persons Braille Literacy Right and Education Act. This bill ensures that Braille instruction be taught to all students K through 12 for the blind that are blind and visually impaired. It will make sure that the individualized education plan of each blind and visually impaired child include provisions for instruction in Braille. We all know that Braille is a system of reading and writing through touch. So it is real important that every child has an opportunity to learn Braille. It impacts every blind and visually impaired person in the state of Georgia. This is actually a very good bill. I ask for your favorable support.
You got it, Senator. You got it. Good job. Does any senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to report on the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor of the bill vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 55 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. I recognize the senator from the 25th for a motion.
Thank you, Mr. President. I'm proud to be your senator, but I humbly ask for your unanimous consent to disinter Senate Bill 168.
Disinter. I'm going to have to check Google on that one. The senator from the 25th has moved that Senate Bill 168 be removed from the table. Secretary, read the caption.
Senate Bill 168 by Senator Williams of the 25th and others, a bill to be entitled an act to amend Part 8 of Article 8 of Chapter 14 of Title 44 of the Official Code of Georgia Annotated, relating to liens of hospitals and nursing homes so as to allow a chiropractic practice to have a lien on a cause of action accruing to an injured person for the cost of care. The Senate Committee on Health and Human Services recommends that this bill do pass. Respectfully submitted, Senator Watson of the 1st District Chairman. Senator Cowser of 46 and others offer the following amendment, Amendment 1, to amend the substitute to Senate Bill 168 by inserting to require the filing of a claim with any health insurer providing coverage to an injured person after action in line 4, by inserting after line 82 the following, C, no filing of a claim or lien under this part shall be enforceable unless the person, firm, hospital authority, or corporation operating a hospital, nursing home, physician practice, chiropractic. That completes the order, Mr. President.
Senate will, unless there is objection, recognize the senator from the 25th to speak to the bill.
Thank you, Mr. President. This is a very simple bill that just lets the chiropractors get paid like everybody else. There's a friendly amendment to the bill, and have no objection to it. If there's no questions, I'll leave the well.
You have no questions, Senator. Senator from the 46, would you like to speak to your amendment in the underlying bill?
Thank you, Mr. President. Senators, I'll be brief. This just says anybody filing one of these type liens, if the injured person had health insurance, they have to first submit their claim to health insurance. And if it's rejected, they can proceed with the lien. Otherwise, no need for their lien. Mr. President, I'll take any questions or yield the well.
You have one question, Senator.
All right.
Senator from the 14th.
Thanks, Mr. President. Senator Yield?
Yes, I yield to one of my co-sponsors of the amendment.
Absolutely. Senator, isn't it true this is one of the rare occasions when people on different sides of tort issues come together to see the plain common sense?
Harmony is lovely. Yes,
Thanks
it
very
is.
much, Senator.
Thank you. I yield the well.
And on that note, Senator, you can yield the well. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of the amendment. Adoption of the amendment, Amendment 1 from the senator from the 46th. Is there objection? Without objection, Amendment 1 is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. The question is on the passage of the bill. As amended, all those in favor vote yea. All those opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 52 and the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed as amended. Recognize the senator from the 33rd to speak to.
Thank you,
Or
Mr.
a motion.
President. I ask unanimous consent to remove 218 from the table.
Senator is asked to move 218 from the table. Secretary, read the caption.
Senate Bill 218 by Senator Rett of the 33rd and others, a bill to be entitled an act to amend Article 5 of Chapter 5 of Title 40 of the Official Code of Georgia Annotated, relating to identification cards for persons without driver's licenses, so as to provide for the issuance of identification cards to persons completing a term of incarceration, to provide that the Department of Corrections share identifying information. The Senate Committee on Public Safety recommends that this bill do pass by substitute. Respectfully submitted, Senator Albers of the 56th District Chairman. The Senate Public Safety Committee offers the following substitute to Senate Bill 218, a bill to be entitled an act to amend Article 5 of Chapter 5 of Title 40 of the Official Code of Georgia Annotated, relating to identification cards for persons without driver's licenses, so as to provide for the issuance of identification cards to persons completing a term of incarceration. That completes the order, Mr. President.
Without objection, I recognize the senator from the 33rd. Another one of those. Be brief, brother, be brief.
Thank you, Mr. President, my fellow senators, colleagues, friends, and y'all. This is a simple bill working with the people from the prisons, such as Rita Rocker, who's the Executive Director of Paroles and Pardon, Robert Thrower, and also the Assistant Commissioner Jay Sanders, that it will help people when they leave prison get either a state ID or a driver's license if they want one. Not the county jails, just the state prisons. Mr. President, I yield well. Thank you.
Thank you, Senator. You have no questions. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 56 and the nays are 0. This bill, having received the requisite constitutional majority and therefore passed. By substitute. I recognize the senator from the 13th for a motion.
Mr. President, I ask for unanimous consent to gently lift Senate Bill 140 off the table.
Senator has moved that Senate Bill 140 be taken off the table. Secretary, read the caption.
Senate Bill 140 by Senator Summers of the 13th and others, a bill to be entitled an act to amend Article 1 of Chapter 7 of Title 31 of the Official Code of Georgia Annotated relating to regulation of hospitals and related institutions so as to prohibit certain surgical procedures for the treatment of gender dysphoria in minors from being performed in hospitals and other licensed healthcare facilities. The Senate Committee on Health and Human Services recommends that this bill do pass by substitute. Respectfully submitted, Senator Watson of the 1st District Chairman. Health and Human Services offers the following substitute to Senate Bill 140, a bill to be entitled an act to amend Article 1 of Chapter 7 of Title 31 of the Official Code of Georgia Annotated, relating to regulation of hospitals and related institutions so as to prohibit certain surgical procedures for the treatment of gender dysphoria in minors. A minority report's been filed. That completes the order, Mr. President.
Without objection, the senator from the 13th is here to. We do have objection. We've got objection with it coming off the table. So all those in favor of the bill coming off the bill, Senate Bill 140 coming off the table, all those in favor of it vote yea. All those opposed, nay. Secretary, unlock the machine. On the motion, the yeas are 32, the nays are 23, and the motion has prevailed. I now recognize Senator from the 13th to present the bill.
Thank you, Mr. President. Colleagues, I'm sure nothing I can say up here is going to change anybody's mind because you probably already made your mind up on Senate Bill 140. But I'm going to give you a little bit of a background on it, and I'm going to sit down and I'm going to ask the good senator from the 1st that helped me work with this bill to get up here and present the medical side of this bill so we'll know what we're talking about. But I want to make one thing perfectly clear. I'm not trying to harm anybody out there or cause anybody any issues whatsoever, so I'm just going to lay it out for you. Senate Bill 140. This bill protects children who are struggling with their gender identity, issuing from being pushed into decisions that will alter their bodies forever. We are banning doctors in Georgia from doing medical facilities and medical facilities from treating gender dysphoria in children through hormones or surgery, because we know most of these children issues will resolve themselves, hopefully when they become young adults. This bill prohibits doctors and medical facilities from prescribing hormones and surgeries as treatments for children with gender identity and gender dysphoria. Violating this statute will result in sanctions from the Composite State Board of the Medical Examiners or the Department of Community Health, including loss of a physician's license. The bill also recognizes that there are some other medical conditions from which hormone surgery may be medically necessary. For example, if a child is born with ambiguous genitalia, suffers from physical injury, or is experiencing precocious puberty. Therefore, this bill delegates the Composite State Board of Medical Examiners to the ability to create some limited liability exceptions for the treatment and otherwise needed to correct the child's physical condition. This bill also has exceptions there for children who are already on hormones. This bill is needed that children whose judgment has not fully developed aren't pushed into decisions they make and regret forever by making a procedure that cannot be reversed. This is simply saying this is a pause, and we're asking for the children to be 18 years or older before they make this decision that will alter their lives forever. And that's basically what 140 does. And Mr. President, I'm going to yield to Will. Thank you.
You have no questions, Senator. Senator from the first, would you like to speak to the bill?
Thank you, Mr. President. I just wanted to thank the senator from the 13th. He has been a really hero with this bill. He has worked tirelessly on this, and he has a very good bill, and I'm here to support that. You know, what we're talking about is children, those 18 and under, who may have irreversible sex change operations, or who may be going through hormone replacement therapy, i.e., testosterone or estrogen. Those are irreversible changes that will affect and live with a person for the rest of their lives. Those are significant things that we cannot discount by any means. But let me just say, what we've tried to do is strike a really good balance. We did leave in the puberty blocking agents, which will give what is termed as a mental pause and allowing them to continue with mental health therapy. That does not do irreversible changes. As a matter of fact, when you stop the puberty blockers in about 18 months, you go through puberty. Now, we use those now in patients who may have autism for when their testosterone kicks in and their mothers are not able to handle them anymore, and they sometimes end up in hotels. So it is used now. It's also used in young girls who start their menstrual cycle at a very early age, sometimes 8 or 9 years old, and sometimes even younger than that. So we use those now, and we do safeguards relating to that, whether it comes with bone health, et cetera. But we do that very judiciously and very thoughtfully. It does allow them, in those who may have this condition, the ability to think about this and allow them to continue with therapy. But let me tell you what it does not do. It does not allow the physician to do that from a surgical standpoint. It does not allow that from a hormone replacement standpoint. Those will be illegal in the state of Georgia. For hospital facilities that condone this and do this, it will be illegal in the state of Georgia. If you're a physician, you'll be able to be reported to your Composite Board of Medical Examiners, and you have broken the law. You will lose your license. If you're a hospital facility or outpatient facility, if you allow something like that to happen, again, you will be subject to losing your license. It does not remove by any means medical malpractice. You will still be liable. It does not change that section of the law at all. As a matter of fact, that is a different section of the law. So, my fellow senators and those listening to us, this is a very difficult bill. There's no doubt about that. I think what we've done is that we have a good bill, is well balanced, is well thought out, And I must applaud the senator from the 13th and those others that are working with me very much and working with our committee, because I will tell you, we have done this in a very organized fashion. We've talked to multiple pediatricians, we've talked to multiple pediatric endocrinologists, we've talked to multiple parents, both pro and con. We've read and reread articles, we've read and reread review articles. We've adjusted and refined this bill to, I think, that we've threaded the needle and made a good bill. Mr. President, I ask for your favorable consideration, and I yield the well. Thank you.
Senator yielded well. Senator from the 40th, would you like to speak to the bill?
Thank you, Mr. President, ladies and gentlemen of the Senate. When I was pregnant with my second child, I didn't care whether I had a girl or a boy. I already had a boy. I wanted a healthy baby. Now, when I found out that I was going to have a girl, I have to admit, I was really happy about that. People would say, "Oh, so you get one of each." I felt really lucky to have one of each. Those years when I raised my children were really happy years. I really loved having a boy and a girl. And I watched my daughter grow up into a beautiful young woman. Then at age 15, she told me she thought she might be a boy. And nothing in my life prepared me for that moment. When I work with advocates and I teach them how to advocate for change, I tell them that it's really important that they live their stories and that they share their stories and that they use their stories to do good. This is my story. I didn't choose this story, but I did choose to be a mom. And when you choose to be a parent, the most important thing for you to do is to love your child. And so I moved forward through that moment, loving my child. It's been 6 years. It's been a hard 5 years, 6 years. The problem I have with this bill is that it only addresses what we won't do for our children. Instead, I really feel like what we need to focus on is what we can do for these kids. Now, let me be clear, I'm in opposition of this bill. But when this happened in my life, I wanted to slow everything down. Things were moving way too fast. I'll be honest, I would have loved it if this law had been in place. But we cannot take away treatment for these kids without having something else in place. And we don't have anything else in place. Now, there are standards of care that have been written for adolescents with gender dysphoria. They're very, very detailed. I'd venture to guess that there's no one in this chamber, except me, who have actually read these standards of care. They were rewritten recently, and there was a lot of controversy in the rewriting of these standards. The reason they were rewritten is because there has been a huge rise in the number of children presenting with gender dysphoria. Probably a rise of, I've read, 3,000 or 4,000%. The people who provide this care and have been providing this care for decades noticed there was a change in who was coming for gender treatment, and some of them did become concerned. That's why they rewrote the standards of care. And what they have written is a nuanced care, individualized care, because every kid and every family is different. So these standards of care that these professionals from all around the world have written these standards of care are slowing down the process already. So what do we need to do for these children? First of all, the practitioners who provide the care, the mental health professionals, the doctors, they need training. Nobody learned about this in medical school. We have counselors out there. These kids are coming to them for help and they don't know what to do. The doctors don't necessarily know what to do. They refer on to endocrinologists who probably are going to treat medically. There's not the infrastructure of trained mental health professionals to follow the standards of care, because the standards of care say that you should get some counseling first. But many families can't afford that, and many counselors aren't trained. So oftentimes that's not happening. Doctors and mental health professionals, they shouldn't be in a hurry to treat with hormones and surgery, but banning them outright is not the answer either. What the standards of care say is that kids need comprehensive assessments so that this care can be individualized. Now, comprehensive does not mean a 1-hour assessment or even a 2-hour assessment. Comprehensive assessment means months of work. These kids need access to mental health care. What we have learned about these kids who have recently been presenting for care is that they oftentimes have other mental problems that they're struggling with. And those things are things like anxiety, depression, eating disorders, ADHD, autism, okay? So we need mental health programs for these kids that we really don't have the infrastructure for, and we certainly don't have affordable options. We need things like the Georgia APEX program. We need more of the Georgia APEX program. This is the program that sends trained counselors into the school so that kids can receive these services there at the school, so they don't have to have a parent, drive after school to see a practitioner. We need more of that because these mental health problems oftentimes, and this is what the standards of care say, need to be treated first before medical transition. Kids need a safe therapeutic space to explore the questions they have with a trained adult. Where are these feelings coming from? What is gender? And how does it impact me? And finally, in terms of the standards of care, it's really important that the families be involved because these kids need their family. They need their parents. And their parents, I can attest to this, it's hard on the parents. And so the parents also need a place to work through these feelings. All of these things are in the standards of care, but we don't have the infrastructure in Georgia. Also, what we should do is we need good data. Are the standards of care being implemented correctly? How many kids are presenting for care? What kinds of assessments are they getting? Are there other mental health issues? Are they getting treatment? If not, what are the obstacles? Are there people who change their minds after medically transitioning? These are all things that we need to know. Another thing we can do, and which the public supports, there was a recent Pew Research Center survey done in June of 2022. 65% of the respondents say that we should pass anti-discrimination laws for transgender people. 25% didn't really care. Only 10% were opposed. And are you curious about how much people care that we are passing these bills here? You might be surprised. 70% said they're not really following these bills or interested in these bills, and less than 10% of Republicans said they are following this issue closely. I thought that was interesting. For Democrats, it's a little higher. It's 15% who are following closely. I listened to a podcast over the weekend. It interviewed a Republican from Utah who stood against his party on the transgender sport legislation. Now, this particular senator had a background in mental health, so he had a real good sense of the mental health struggles of these children. He stood against his party and voted against the ban on transgenders participating in sports. Now, when he did that, he had a district that was +7 Democrat. Then he went through redistricting, and his new district was +23 Republican. He voted against the transgender treatment ban in Utah. He figured it was the end of his career, but he won re-election. I had a discussion with my son who used to be my daughter, this weekend. Now, when I told you about my son last year, we had a much more strained relationship. And I told you we communicated through a Google document about issues that were so hard to communicate that we couldn't talk in person. We have graduated to FaceTime. And honest to God, that's because I've had 8 months of therapy, dealing with my grief and my fear, so that I could go forward with my relationship with my child. My son said to me, "Mom, I've been thinking about humility and what humility means." He said, "I looked it up in the dictionary and it said to be meek and modest and to have a low view of one's importance." And he said, "That's not what humility is, Mom. I've been thinking about humility in terms of what it means in a community." And he said, what it means is that you recognize what you don't know, and then you seek others out to fill the gap. And he said, "Thank you, Mom, for showing humility last year when you had the transgender and sports bill, and you came to me and asked me what I thought." Wow, that was a mom moment. Everyone's gonna push a yes or no button in a few minutes, but none of us knows much about this subject. And we don't know what these kids are going through. If this bill passes, and it probably will, some desperate kids are going to feel more desperate. Some parents are going to be angry, and I'll be honest, some parents are going to secretly breathe a sigh of relief because it will slow things down. There are a number of countries in Europe that have abandoned the medical model, and they've gone to a psychotherapeutic model of support. We could have that discussion, but we can't do what we're about to do today because we do not have the infrastructure in our state for providing that psychotherapeutic support. That's something we need to work on. So going forward, let's all bring some humility to this issue. Let's admit let's admit what we do and what we don't know. And when we don't, let's ask someone who does before we take action. Thank you. I don't know whether there are any questions. I don't know whether I want to answer any questions.
You have no questions, Senator.
Thank you. I yield the well.
Senators yielded the well, and I recognize the senator from the 41st, who I believe has the minority report.
Thank you, Mr. President. I want to begin by acknowledging the senator from the 13th. I know that you have said many times that your intention is not to harm any children, and I believe that your heart is sincere. However, I believe that this bill ultimately is harmful. I want to also start by acknowledging the trans and non-binary and gender divergent youth and adults who are watching. Some of you are in the gallery, some of you are in the hall, and many of you are at home. I want you to know that we see you, we love you, and we stand with you. Now, in the words of the senator from the 9th, I think we need to have some real talk about what this bill does. You see, when we don't provide children with medical supported gender affirming care, we already know what happens to them. When a child doesn't receive the care that they need, they will find themselves binding their chest with duct tape and other materials so tightly that doctors have reported that there's been bruising and then breaking of ribs, because they haven't had medically supported gender-affirming care. We know, we've heard the stories of people who are tuck, and then they end up with urinary tract infections again because they have not received the affirming care that they need. And we also have heard the stories of people, young people, cutting at and cutting off parts of their body that don't match what they want to see in the mirror. That's what happens when children don't have access to the kind of care that they need. I'm not making these things up. We know this to be true. Listen, I understand that you may not get what it is to be trans. You may not understand what it is to look in a mirror and see reflected back to you an image that doesn't match how you feel inside. And you don't have to understand it. I'm just asking you to be compassionate and empathetic towards it. Let's say that you do give a child puberty blockers. They take the puberty blockers, and when you're 12, it's fine not to go to puberty. When you're 13, it's probably fine not to go through puberty. But when you're 16 and you've been on a puberty blocker since you were 12, there are real medical problems that come if you're not allowed to have hormone replacement therapy alongside of it. There are bone density issues that can occur. There are all types of problems that can happen when you don't receive the hormones that all of us, when we go through puberty, need. So we cannot leave a child on puberty blockers and not prescribe them with the hormones that they need to make the transition. And so you know what happens when young people can't get access to the medical affirming care that they need? When they can't get access to the hormones that they need, you know what they do? They go to the black market. They go online where they can find testosterone, and you don't know what's in that pill or what's in that injection. They go and they find a friend of a friend of a friend who says, hey, I've got some estrogen with you, and you have no idea what's in it. That's what happens because young people are smart. And when they need access to hormones, they will either get it the right way through a medical professional or the way that's most harmful on the black market, in the back alleys. And here's the other piece. the part that we have to name out loud. When young people don't receive the gender-affirming care that they need, they die. We know this. Trans youth are 86% of trans youth report that they have considered suicide. 56% have reported they have tried to die by suicide. We also know that this debate alone, just the fact that we are having the conversation, provides great angst and is harmful to the very people who are having to listen to it, to children who are watching grown-ups make decisions about whether or not they and their parents and their doctor can make decisions about their bodies. Just the conversation alone puts their mental health at risk. And we know that if this bill were to pass, and if children were denied access to the care that they need, it's care that they don't just wake up one day and say, you know what, I think I'm a girl. It's care that they receive after going through therapy and counseling, after conversations with their parents and doctors. It's care that is carefully considered. But if this bill passes, if it becomes a law, we know that this bill actually may be deadly. Deadly. Now, I know there's been some concerns about children having procedures that may be irreversible, but you know what the ultimate, most irreversible thing is? It's suicide. It's death. For me, more than anything, this is about mental health care. This is about making sure that children can be well while they go through a season of transition. This is about making sure that we create a state, a place, where children who are gender divergent know that they have a place here, where they can be safe, where they can receive the care that they need in a way that is good, not on the black market. Not something that they do in a bathroom by themselves where they're binding until they break their ribs. We are trying to create a state where our kids can just be safe. I'll end where I started. To the parents in the hallway, to the youth in the gallery and outside in the hallways, to all of the trans and non-binary kids who will see this and watch this, know that we love you. We see you, and we stand with you. And to my colleagues, I ask that you would vote no on this, not because you understand, but because you have compassion in your hearts for what these children are experiencing. With that, Mr. President, I will yield for questions.
There are no questions, Senator.
Thank you.
Senator's yielded well. Senator from the 13th, do you want to close debate? Senator is waived. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. The question is on the passage of the bill by substitute. All those in favor signify by saying aye. All those opposed, no. Secretary, unlock the machines. On the passage of the bill, the yeas are 33 and the nays are 22. This bill having received the requisite constitutional majority is therefore passed by substitute. Recognize the senator from the 23rd for a motion.
Thank you, Mr. President. I ask for unanimous consent to take SB 213 from the table.
Senators move that Senate Bill 213 be lifted from the table. Secretary, read the caption.
Senate Bill 213 by Senator Burns of the 23rd and others, a bill to be entitled an act to amend Chapter 66 of Title 36 of the Official Code of Georgia Annotated relating to zoning procedures so as to prohibit local governments from preventing the continuance of lawful nonconforming use of property when a pre-existing manufactured home or mobile home is replaced with another such home. The Senate Committee on Sligo General recommends that this bill do pass by substitute. Respectfully submitted, Senator Ginn of the 47th District Chairman. The Committee on State and Local Government Operations offers the following substitute to Senate Bill 213, a bill to be entitled an act to amend Chapter 66 of Title 36 of the Official Code of Georgia Annotated, relating to zoning procedures so as to prohibit local governments from preventing the continuance of lawful nonconforming use of property. That completes the order, Mr. President.
If there's not objection, I recognize the senator from the 23rd to speak to the motion.
Thank you, Mr. President. You know, colleagues, the hour is late. We've dealt with some challenging issues. And I want to extend grace to my friends on both sides of the aisle as we have been challenged this evening. Ladies and gentlemen, my bill is not a controversial bill. It's a straightforward bill that would allow someone who owns a manufactured home to replace that home with a new unit within 12 months to improve their living conditions. It allows for non-conforming use, unless there are special exceptions. And the reality is this is an affordable housing bill. It's a personal property rights bill. And I would appreciate your support as we do what's right for the citizens of Georgia. And without further ado, Mr. President, if I have no questions, I'll yield well. Thank you.
Senator has yielded the well. But Senator from the 26th, I always love to hear your opinion on things, so please share.
Mr. President, I'm not a lawyer. I'm what they call a street lawyer. Get it out the street. Look, what I wanted to ask the gentleman in the well, parliamentary inquiry, isn't it true some might not be able to replace within a 12-month period, that they might have financial wherewithals that might prohibit them from replacing that unit within 12 months, and that they ought not to be penalized because they might be having financial problems?
Senator may know what he speaks. I didn't hear his presentation there, Senator, so you might want to talk to the author about that. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. Secretary will unlock the machines. On the passage of the bill, the yeas are 45, the nays are 10. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 9th for a motion.
Mr. President, I ask that Senate Bill 35 be lifted off of the table.
Senator from the 9th is requested that Senate Bill 35 be lifted off the table. Secretary, read the caption.
Senate Bill 35 by Senator Merritt of the 9th and others, a bill to be entitled, an act to amend Code Section 4286 of the Official Code of Georgia Annotated, relating to special license plates promoting or supporting certain worthy agencies, funds, or nonprofit corporations with proceeds dispersed to the general fund in the agency fund or nonprofit corporation. The Senate Committee on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers of the 56th District Chairman. That completes the order, Mr. President.
Without objection, recognize the senator from the 9th.
Thank you, Mr. President. Members, I bring you a very easy bill and very quick bill, Senate Bill 35. This is a license plate honoring the fine gentlemen of Kappa Alpha Psi fraternity, and it is a special license plate to support members of Kappa Alpha Psi fraternity. The funds raised by the sale of the special license plate shall be dispersed to the Southern Education and Leadership Foundation, and I ask for your favorable vote this evening. Thank you. Mr. President, I yield the well.
Senators yielded well. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objections to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. You just leave it on the table, man. Yeah, that's your preference. Yeah, I think so. You don't have the votes. I'm telling you. I don't want to. On the passage of the bill, the yeas are 55 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. All right, here we go. We're rounding up the night now. Senator from the 47th, for what purpose do you rise? Senator, you waving?
Parliamentary inquiry.
What's your inquiry?
Would it be appropriate to ask for Senate Bill 34 to come off the table? Because I've served on the study committee, and it's a good bill.
I'm sure it is, much like a lot of these bills we have here, Senator. But right now, I'm going to call on the senator from the 29th for a motion.
Ask for unanimous consent that Senate Bill 158 be lifted from the table.
The senator has moved that Senate Bill 158 be lifted from the table. Secretary, read the caption.
Senate Bill 158 by Senator Robertson of the 29th and others, a bill to be entitled, an act to amend Chapter 32 of Title 33 of the Official Code of Georgia Annotated, relating to property insurance so as to provide for an insurance premium discount or rate reduction for property owners who build a new residential or commercial property or who retrofit an existing residential or commercial property. The Senate Committee on Insurance and Labor recommends that this bill do pass. Respectfully submitted, Senator Walker of the 20th District Chairman. That completes the order, Mr. President.
Recognize the senator from the 29th.
Thank you, Mr. President. Colleagues, Senate Bill 158 is a piece of legislation that we passed out from this body last session. All it does is give a opportunity for reduced premium rates to those individuals who are willing to build their homes up to a fortified standard. It's a national recognized standard that allows it to withstand hurricanes, tornadoes, and other wind damage incidents better, thereby lowering premiums and damage to the property. With that, Mr. President, I yield the will and encourage everyone to support Senate Bill 158.
Does any other senator wish to speak for or against the measure? Chair hearing none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question on the passage of the bill. All those in favor will vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 56 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Let me pause for a second. We've got a very, very special young man here. Carson Hickman is our alone page standing right now. So come on down. If that name sounds familiar, that's because it's the senator from the 4th grandson right there. So he's either a really hard worker or the senator is his only ride home. One of the two right now. He earned every bit of that. I recognize the majority leader for a motion.
Thank you, Mr. President. I move the Senate stand adjourned until Tuesday, March 7th at 1 p.m.
The majority leader has moved that the Senate stand adjourned until Tuesday, March 7th at 1 p.m. Secretary, read the announcements.
The Insurance and Labor Committee meeting will happen at 10 a.m. tomorrow in 450 of the Capitol. The Higher Education Committee meeting will happen at 10 a.m. in 307 CLOB of the Capitol tomorrow. The State Institutions and Property Committee meeting will happen at 11 a.m. in 450 of the Capitol. The Children and Families Committee meeting is canceled. The Education and Youth Committee meeting will happen at 3 p.m. in 307 CLOB. The Regulated Industries and Utilities Committee meeting will happen at 4 p.m. in 450 of the Capitol. The Health and Human Services Committee meeting will happen at 5 p.m. in 450 of the Capitol. And the Rules Committee meeting tomorrow will happen upon adjournment in 450 of the Capitol. That completes the order, Mr. President.
The majority leader has moved that we stand adjourned until 1 p.m. Tuesday, March the 7th. All those in favor signify by saying aye. All those opposed, no. The ayes clearly have it. We're adjourned. Y'all have a good evening.